The Ateneo Alumni Association has evolved from its image of a boys' club in the early years to the image of an active alumni association of men and women for others.
I think it's very important to remember that the Ally performs a very important education value. The education of our graduates ends not with graduation, but with their continuing practice in introduction into the legal world.
This is a big task, but I believe everything is possible as long as you believe in our dear Lord. And as Atenean lawyers, we do believe. And with your help, we will be able to do it. Let us continue to be men and women for others. Join the Ally.
Join us!
Join us!
Join us.
The Ateneo Alumni Association has evolved from its image of a boys' club in the early years to the image of an active alumni association of men and women for others.
I think it's very important to remember that the Alumni performs a very important education value. The education of our graduates ends not with graduation, but with their continuing practice in introduction into the legal world.
This is a big task, but I believe everything is possible as long as you believe in our dear Lord. And as Atenean lawyers, we do believe. And with your help, we will be able to do it. Let us continue to be men and women for others. Join the Alumni.
Join us! Join us!
Join us.
Hello, good afternoon to all viewers here at the Facebook page of the Ateneo de Manila Law Alumni Association, Inc. I am Jose Martin Tensuan, please call me Martin. I'm the External Vice President of the ALAI, and I'd like to warmly welcome you this rainy afternoon to the Father Joaquin Bernas SJ E-Lecture Series. This project, named in honor of Father Joaquin Bernas, the Law Dean Emeritus of the Ateneo de Manila, who has led our alma mater to greatest heights for his laudable accomplishments as a constitutionalist and as amicus curiae of the Supreme Court. As we all know, Father Bernas' deep analysis of legal issues moved decision makers in the government, legal advocates, citizens, and media to take direct action on national issues. This web lecture series project is in keeping with Father Bernas' directive that the alumni should promote the passion for justice and advance our legal education. This series was launched on this channel to allow the ALAI to reach an expanded audience, both alumni and non-alumni. As you know, we started I think on Zoom where we had a few hundred and a few thousand, but a lot of people became enthusiastic in following the lecture series. So here we are now using this different platform. Our goal is for our speakers not just to lecture about relevant topics, but more importantly, to help the viewers understand new laws and jurisprudence and their effects on their day-to-day lives. So on behalf of the Ateneo Law Alumni Association, headed by our chairman, Teddy Cruz, and our president, Nena Rosales, allow me to formally open the 6th session in the series of web lectures, now referred to as the Father Joaquin Bernas SJ Lecture Series, and in honor of our esteemed Jesuit constitutional law luminary. I'd like to call my fellow Alai trustee and Alai's Director of Communications, Attorney Mitoy Fernan Cayosa, to introduce our speaker of today. Mitoy.
Thank you, Martin. Good afternoon to all our viewers. Our very competent speaker today earned his Bachelor of Science degree in Management, major in Legal Management at the Ateneo University in 1990. In 1994, he finished his Juris Doctor course with second honors at the Ateneo Law School and was given the Evilio Javier Leadership Award, having served as president of the Ateneo Law Student Council. He was among the top 5 in the 1994 bar exams and was admitted to the practice of law in 1995. Immediately after graduation, he joined the CCIP Salazar, Hernandez, and the Paitan law offices. He started teaching at the Ateneo Law School as professor, bar reviewer, and later becoming vice chairperson of the Labor Law Department, a position he holds at the law school to this day. He previously taught at the University of Santo Tomas, Faculty of Civil Law, and apart from that, he was also teaching at the Pamantasan ng Lungsod ng Manila College of Law and the Ateneo de Manila University's Department of Development Studies and Department of Political Science. Apart from the Ateneo Law School, our speaker is currently a professor and bar reviewer at the San Beda College of Law. Our lecturer today began to heed the call to work in non-governmental organizations in 1996 when he joined the Sentro ng Alternatibong Lingap Panligal or Saligan, a national legal resource NGO engaged in developmental legal work with farmers, workers, the urban poor, women, and local communities. He served in various capacities as an associate, later as coordinator for the Saligan Local Governance Unit, and eventually serving as its executive director until the year 2007. In 2008, our speaker became coordinator of the Alternative Law Groups, a coalition of more than 20 Philippine NGOs that adhere to the principles and values of alternative or social development-oriented law practice. These organizations have distinct programs for legal assistance that is primarily concerned with the pursuit of public interest, respect for human rights, and promotion of social justice. Since then, he has been connected with various NGOs promoting social justice and protecting the rights of the marginalized. He was initially appointed by the President as sectoral representative for NGOs at the NAPSI, or the National Anti-Poverty Commission. Subsequently, his fellow sectoral representatives elected him vice chairperson for the basic sectors, representing all 14 basic sectors of NAPSI. Our lecturer today has also been involved in numerous programs and projects on integrity and good governance. He was chairperson of the Project Steering Committee Justicia Natin, empowered civil society participation in monitoring judicial and quasi-judicial bodies towards enhanced integrity of the justice system. A 3.5-year project supported by the European Union, he gave valuable inputs on the issue of corruption and accountability in the Philippines to the report that had been acknowledged in other international reports. His inputs were also cited among references in the Global Integrity Report, an investigative report tracking corruption, openness, and accountability in 25 countries, and again in 2007 in a global corruption report in judicial systems published by the Cambridge University Press. He is currently Senior Advisor to the Legal Empowerment Network, Namati, and is acknowledged in the international community as a major convener of the Pro Bono Movement, an annual convention of organizations providing pro bono legal services worldwide. Our speaker is currently a law partner at the Mendoza, Pag-aw, and Manuel law firm. Given his background and experience, our speaker will definitely be able to give us updates on labor law from two perspectives. First, from the rights and obligations of employees, and to the interests and obligations of employers. On a personal note, let me just state that while our lecturer has worn many serious hats, he has a lighter side, and that is he is a good singer, dancer, and a juggler. Ladies and gentlemen, I am proud to introduce my classmate, an eminent expert on labor law, a man for others, Attorney Marlon JULIANO Manuel. Thank you, Martin.
Thank you, Mitoy. Thank you, Martin. Good afternoon to everyone. Magandang hapon po sa inyong lahat. I recall we were together in law school, Mitoy and Martin, in the early 1990s. And that period was more than 2 decades ago, and the world is totally different from what it used to be. I remember in law school we were just thinking about the construction of the EDSA flyovers, the rationing of fuel at that time. Now it's a whole different world for us. Okay. Shall we start?
Yes, Marlon, if you're ready.
Yes, Marlon.
Yes. Okay. Thank you. I'll try to limit the presentation, the lecture, to just a little over 1 hour. So we will have enough time for the questions. When I was invited to make this presentation, my initial reaction was, this is not a good topic. Not a good topic in the sense that this is a sad situation for all of us if we are discussing termination of employment and closure of establishments. But I would say this is a very relevant, very timely issue for us to discuss. And I'd like to thank the Ateneo Law Alumni Association for bringing us together, even online, for this very important discussion on this issue. For this afternoon, I propose to discuss the 4 major areas. We will be focusing on different modes of adjusting to a particular financial economic situation. And we will look at this in the context of the pandemic. So we will start with temporary suspension of operations and related measures, termination due to redundancy, retrenchment to prevent losses, and then closure or cessation of operations. We will go through them one by one. But before that, since we would like to contextualize the discussion in the current situation, let us start with a few statistics. The Philippine Statistics Authority issued the results of the April 2020 labor force survey recently. And the results are not good, as you all know. Unemployment for April 2020, for the second, this is almost the second quarter, is 17.7%, or 7.3 million Filipinos. If you compare this to last year's unemployment rate, last year's April 2019 unemployment rate is only 5.1%. So from 5.1%, now it's 17.7%. And just at the start of the year, in January 2020, it was just 5.3%. So 5.1% last year, well, April last year, and then 5.3% at the start of the year, January. And then in April, it went up to 17.7%. All regions reported double figures in their unemployment rates. And let us look at Metro Manila. April 2020 figures, unemployment rate is 12.3%. So again, if we compare it on a year-to-year basis, last year, April 2019, unemployment rate in Metro Manila, National Capital Region, was only 6.3%. So even the Philippine Statistics Authority, PSA, recognizes in the report that this is unprecedented. This is a record high unemployment rate historically. So we are experiencing a very difficult situation insofar as employment is concerned. A couple of days ago, social weather stations released the results of the survey on joblessness, on adult joblessness. And again, similar to PSA, SWS reported record high figures, 45.5%. 45.5% in its July 3 to 6 mobile phone survey. This is a 28-point increase. According to the SWS report, this is a 28-point increase from the December figures, December 2019, of 17.5%, and a new record high since the 34.4% in March 2012. So March 2012 was 34.4%. We surpassed that. It's now 45.5%. And the SWS survey also found out that half of those with no job or with no livelihood at the time of the survey lost their livelihood during the COVID-19 crisis. So half of those who are jobless just lost their jobs in the last few months because of the crisis. If we look at the unemployment rate and looking at the figures of the Philippine Statistics Authority, there is a component that is not there. And the PSA report will explain this, that overseas Filipino workers are not included in the labor force, in the Philippine labor force. They form a separate statistics altogether. And last Sunday, there was a press release issued by the Department of Labor, Secretary Bello. And the Department of Labor estimates that displaced OFWs will now reach 600,000. And this is an increase from previous estimates, 600,000. And about 350,000 of these are stranded in other countries. They are displaced. They are on-site workers who have lost their jobs. They are displaced and stranded overseas. The remaining 250,000, about 250,000, are repatriated land-based and sea-based OFWs. So two related statistics from the government and from the survey of the social weather stations. Now, let us look at the overall situation of the economy, not just the unemployment, not just the unemployment rate. So this is a very short video from the PSA about the Philippine economy. Let's watch this video. So for quarter 2, 2020, there's a huge drop in economic growth. Industry declined 22.9%. Services declined 15.8%. So this is official government statistics, official government data from our PSA. That's the context of our discussion. And when we discuss the 4 major areas, we will go through them one by one, starting with the mildest. The mildest being the temporary suspension. And then from there, we will go to the other areas: redundancy, and then retrenchment, and then closure and cessation of operations. This lecture, this webinar is open to the public, so not just to lawyers, but to the public in general, to managers, to law students, to union leaders, to employees. So I will not be too technical in the discussion. We will avoid citing Supreme Court decisions or specific provisions of law. We would rather be more practical and apply the laws and jurisprudence to our given situation now, the pandemic. That's how we will do the discussion. Let's start with temporary suspension of operations. I just included the article just to cite the labor code provision and just to emphasize that our laws specifically allow the temporary suspension of operations. So companies can temporarily suspend their operations. Now let us look at what it means to temporarily suspend operations and what are the requirements. The first requirement is that the suspension must be bona fide. It must be in good faith. What does this mean? It means that the motivation of the employer is based on primarily or purely business or economic reasons, not to circumvent the rights of employees, not to circumvent or defeat the exercise of employees of their right to self-organization. For example, so this is a fundamental requirement for all the different exercises of managerial prerogative, that the employer exercises the rights of the employer, the managerial prerogatives, in good faith. The law limits the period to 6 months. So there is a maximum period for the temporary suspension of operations. The law says not more than 6 months. And during that 6-month period, even if it can be considered as a prolonged period of absence from work, it will not be considered as a termination of the employment relationship. So the parties, the worker and the employer, are still engaged as employer-employee relationship. The employment relationship is not ended. And because of that, because it is not ended, there is no need for separation pay, because this is not a case of termination. It is just a suspension of operations. The relationship of employer-employee continues. You are not dismissing the employee from the job. What will happen at the end of the period? So the law limits it to 6 months. At the end of the period, what will happen? After 6 months, then the employees must be given work. So there must be a resumption of operations. Or if the employer cannot do that, if the employer cannot resume operations, the employees must be permanently terminated from employment. So if we look at the law, and as applied and interpreted in jurisprudence, there is no extension beyond 6 months. There is no extension of the 6-month period of suspension of operations. The only requirement is that there has to be a bona fide intent on the part of the employer to address a particular situation. Let's give an example. In one case decided by the Supreme Court, there was a fire that destroyed the building, that destroyed the factory of the company. The Supreme Court said that's a justification to temporarily suspend operations. I remember a few years ago there was heavy flooding in Thailand, and because of that, supplies of spare parts or for automobile assembly in the Philippines had been affected. And at that time, some manufacturing companies, automobile assembly plants, suspended operations for a short period, not exceeding 6 months, because of that. So those are examples of situations that will justify the suspension of operations for 6 months. What will happen if at the end of 6 months, there is no resumption of operations? That is what the Supreme Court will call constructive dismissal. So if the employer will not hand out a notice of dismissal at that time, if the employer will not tell the employee, you are hereby terminated from employment because we have ended the 6-month limit in the law, then the court will consider that as constructive dismissal. Constructive meaning even in the absence of an actual dismissal by the employer of the services of the employees will be considered under the law as terminated. This is very important today because we are approaching a critical stage. We started the lockdown March 15. So April, May, June, July, August, September. By middle of September, we will be ending the 6-month period from the start of the lockdown. So for those employer establishments that had not operated since the start of the lockdown in March, they are approaching the end of the 6-month period. So this discussion is very timely. I hope the Department of Labor and Secretary Bello in particular are preparing for this. They should be preparing for this because in the next few weeks, we will be seeing the operation of Article 301 of the Labor Code concerning the temporary suspension of operations. I have a question for everyone. And you have to think about this as an argument that can be raised by employers, by establishments in this period. Can a company say that, well, the suspension of operations is not my decision. It is due to causes beyond the control of the company. It was the government in the first place who ordered the lockdown, and that caused the operations of the company to be suspended. That's a valid point. How will we address that particular argument? I would say that there is no specific decision that covers this kind of situation because this is unprecedented. The pandemic that we have is unprecedented. But I would say that based on a reading of the provision, Article 301, and based on previous cases decided by the Supreme Court, Article 301 still applies. Let us look at the wording of the provision first before we go to jurisprudence. Article 301 lumps together under the same provision suspension of operations, bona fide, in good faith, and including a military performance of a military or civic duty or service by an employee or by the employees. So if you look at that combination, the military service of the employees is something that is also beyond the control. This is the draft. Ito yung tinawag ka na maging sundalo sa giyera. And that is what is considered in Article 301. That is also not the fault of the employer. That is due to causes beyond the control of the employer. There are a few cases that can guide us in trying to understand the answer to this question. And one is a case that involved Manila Mining Employees Association and Manila Mining Corporation. This was a 2010 decision of the Supreme Court. In that case, the company cited this particular position. Hindi naman namin kasalanan. And the company at that point was waiting for a permit from the Mines and Geosciences Bureau, from the DNR. It did not get the permit. So there was a suspension of operations. So the company was saying the 6-month limit should not apply to us. The company argued that we should not have a deadline, that we can extend beyond 6 months for our suspended operations and not be liable for dismissal, for constructive dismissal. The Supreme Court still held Manila Mining Corporation liable for constructive dismissal in that case and ordered the payment of separation pay. Very recently, we have the case of the Boracay Closure. And this will show us how the Department of Labor will treat this pandemic in relation to Article 301. If you remember, Boracay was closed from April 26, 2018 to October 25, 2018 under a proclamation 475, declaring a state of calamity for the area. The Department of Labor, in its issuances concerning Boracay, had referred to it as suspension of operations without terminating the employer-employee relationship. So take note that the Boracay closure is also not a voluntary act on the part of the employer, but a government-induced or a government-compelled suspension of operations. So if we look at those two cases, and if you look at the wording of Article 301, which includes military service of employees, we can say that even if the suspension is due to causes beyond the employer's control, Article 301 should still apply. And therefore, the 6-month limit must still be followed. So what is the effect? So at the end of the 6-month period, after 6 months, employment shall be deemed terminated if there is no resumption of operations. So the company will be considered to have terminated the employees if there is no resumption of operations after the lapse of the 6-month period. That's why the government, the Department of Labor, should act immediately. We have a few remaining weeks before the end of the 6-month period. So the Secretary of Labor should guide employers and should be prepared for this. Otherwise, you will have multiple companies either terminating employees or companies risking potential liability for being covered by the application of Article 301 as applied and interpreted by our Supreme Court. A few more weeks left. Generally, if we consider that there is a termination, if there is no resumption of operations beyond 6 months or after the 6-month period, generally, there will be liability to pay separation pay. I'm saying generally because this will be subject to our discussion later on some rules concerning the payment of separation pay. But at this point, let's just say that employers will be risking the liability to pay separation pay to dismissed employees if the suspension of operations will continue beyond 6 months, and in our case, beyond September 15. And that will be next month. Now, we have to make a distinction between suspension of operations and some other measures short of suspension of operations. So we can consider a floating status. Some will call it off detail, prolonged leave without pay, temporary layoff. How is this different from suspension of operations? In suspension of operations, the whole company stops operating. In these measures, instead of suspending operations, only some employees will not be working. In fact, many decisions of the Supreme Court involved security guards who had been placed on floating status. So hindi lahat, hindi mo sinasara ang kumpanya, pero may mga empleyado, may mga manggagawa na walang trabaho. Floating, off detail, no work, no pay. Leave without pay. So iba-ibang pwedeng terminology dito, temporary layoff. So no suspension of operations, but one or some employees are placed under a situation where they do not work and they do not receive any payment. There is no specific provision in the law about this, unlike suspension of operations. But the Supreme Court had applied the same provision that applies to suspension of operations by analogy, according to the decisions of the Supreme Court. Article 3.1 should apply by analogy to situations where one or some employees are placed under a floating status without work without pay. What does that mean? We apply the same limitation as to period. So you cannot be placed under a floating status for a period more than 6 months. That's what the court said. And as I said earlier, many of the cases involving floating status involve security guards. So naghihintay yung security agency ng bagong kontrata with a client, and in the meantime, hindi kailangan yung services ng isa or a set of security guards, naka-floating status sila. The Supreme Court said, pwede yan, basta hindi ka lalampas sa 6 months. So the court applied the rule on suspension of operations under Article 301 to the case of employees who are placed under a prolonged leave without pay or temporary layoff, and the court imposed the limitation of 6 months. So same formula applies. So what we have discussed earlier about suspension of operations, the same formula will apply, meaning after 6 months, the employees who were placed under floating status must be called back and must be given work or permanently terminated. And if there is no termination, actual termination done by the employer, they will be considered under the law constructively dismissed. So even without the employer giving the notice of termination, even without an actual termination by the employer, under the law, the employees who were not recalled to go back to work will be considered as terminated at that point. Again, that raises consequences concerning the payment of separation pay, the liability of the employer. We will go back to that later. One important clarification, and the Supreme Court had applied this to a case involving security guard. So in one case, ganito yung nangyari. Yung security guard, naka-floating status siya for 6 months. Before the end of the 6-month period, nung patapos na yung 6-month period, sabi ng employer, back to work. Or sabi ng employer, report. So nag-report siya sa office. Nung nag-report siya sa office, wala pa rin trabaho na binigay sa kanya yung employer, yung security agency. So balik siya sa situation na wala siyang trabaho, wala siyang sweldo. The court said that is not a report back to work order. That is not a recall of the employee. So the court said, hindi na-cut yung 6-month period. The court said, ang dapat mong gagawin, pagkatapos ng 6 na buwan, bibigyan mo ng trabaho yung manggagawa, yung empleyado. At pag hindi mo siya nabigyan ng trabaho, hindi pwedeng ipapatawag mo lang siya sa opisina at sasabihin mo, oh, wala pa tayong kliyente, so wala ka pa rin trabaho, o wala pa tayong raw materials, so extended pa rin ang suspension mo, temporary suspension or floating status. The Supreme Court said that will be in violation of the maximum of 6 months. So the court applied strictly the rules concerning suspension of operations to floating status or temporary layoff of employees. So take note of the difference. Suspension of operations, sarado. Buong establishment. Pagdating sa floating status, off detail, prolonged leave with pay, tumatakbo yung kumpanya, tuloy yung operations, pero isa or iba, may ilang mga manggagawa na walang trabaho, leave without pay. And the same rule applies. Article 301 of the Labor Code applies to both situations. Another question. Can the employer, instead of suspending operations or instead of putting employees under floating status or temporary layoff, can the employer instead adopt a system of rotation? Especially now with limitations on the number of employees that can be reporting for work for a given company, can the employer adopt a system of rotation with reduction of either number of days or hours of work for employees? These measures are specifically allowed under the Department of Labor's guidelines on flexible work arrangements. If you look at the guidelines on flexible work arrangements, halos parehong-pareho yung guidelines ng Department of Labor na in-issue for the pandemic and yung in-issue nila for Boracay. Halos pareho. If you look at the adjustment measures, the guidelines, the advisories issued, there are parallel issuances by the Department of Labor that apply to the 6-month suspension of Boracay and the current pandemic. So let us start by answering the question and saying the Department of Labor allows this. We have to note, however, that in previous cases decided by the Supreme Court, the court considered reduction of work hours as dismissal. So balik tayo dun sa term na constructive dismissal. Kahit hindi ka tinanggal ng employer mo, yung sitwasyon ay ituturing na pagtanggal sa trabaho. So even if there is no actual dismissal by the employer, you will be considered as constructively dismissed. And the Supreme Court cited two important elements, two important reasons for treating the reduction of work hours as dismissal. And these are, number one, the court said there is a significant reduction in salary. In one case, for example, the employees were given work for only 2 days in a week. So the Supreme Court said that would amount to a significant reduction of salary. And second, the court said, related to that, that would amount to deprivation of gainful occupation. This is a very problematic situation during the pandemic. And this is a dilemma for employers. So anong gagawin ng employers? Can they do this? Can they do a rotation? Can they reduce the number of hours, the number of days? My advice for employers and for employees also is to have a clear agreement if ever this will be adopted by the company. In fact, the Department of Labor requires a reporting of the flexible work arrangements. But more than the reporting of the flexible work arrangements, I think it's more important that this be discussed. If there is a union, then the union must discuss this with the employer. In the absence of a union, the employer should still discuss this with employees. We have to address this crisis together, and this is one problem that we have to address. There can be risks, there can be liabilities, and the employer may be opening itself up to liabilities because of previous decisions of the Supreme Court concerning reduction. On the other hand, sabihin naman ng employer, pag hindi naman ako nag-reduce, baka mapilitan akong magsara. And that's understandable. That's a very reasonable concern on the part of the employer. So I would suggest if flexible work arrangements will be adopted, not only within the 6-month period, but even after, because there can be restrictions on the number of employees who can work at a given company, at a given factory, that the employer and the employees should clearly document the process of discussing this, of agreeing this, so that if ever there would be a dispute, then the employer will be protected. And the employees as well will have protection if there is a documentation of the agreement. Otherwise, again, as I said, this opens up to potential liabilities because of the decisions of the Supreme Court considering significant reduction in work hours as amounting to constructive dismissal. But this is covered, as I said, this is covered by the Department of Labor's guidelines on flexible work arrangement. Specifically, there is a Labor Advisory number 9 issued by the Department of Labor at the start of the crisis. Okay, let's move to the next topic, the next area. So we are leaving suspension of operations and the flexible work arrangements. Let us now go to redundancy. What do you mean by redundancy? The term redundancy has been explained as superfluity. So yung English term na redundancy, parang paulit-ulit or doble, sobra. Okay, that's the meaning of a situation of redundancy under the law. So it's a superfluity, meaning you have employees in excess of what you need for your current operation. Sobra ang dami ng tao mo. And because of that, the law authorizes the employer to reduce the number of employees. So this is an authorized cause for dismissal. So take note, unlike suspension of operations, this is dismissal. Suspension of operations is not termination of the relationship. This is a termination of the relationship initiated by the employer. And the law specifically gives the employer the right to do that. This is one of the authorized causes. What are the requirements for this? Again, it has to be done in good faith. The employer should be motivated by legitimate business reasons for redundancy. One requirement for this is that there has to be a set of criteria for the employer's selection of employees to be terminated. Why is there a need for a criteria? Because in redundancy, you don't close down the whole company. You don't dismiss all employees. You only dismiss some of them. The question is, who will be the unlucky, the unfortunate employees who will be part of the redundancy program? And that is where the criteria becomes an important element, an important requirement. We will be covering the same element criteria when we go to retrenchment. So we will be going back to this. In many cases, Supreme Court said there is a requirement for the employer to prove the fact of redundancy. Kailangan mapatunayan mo itong sitwasyon na ito na sobra ang mga tao, sobra ang mga manggagawa sa pangangailangan ng kumpanya. Why did the court say that? The court said that because in some cases, and in some decided cases, the company would simply declare a redundancy program. And after such declaration of the redundancy program, will implement it and reduce the number of personnel, the number of employees. The Supreme Court said you cannot do that. The declaration of a situation of redundancy is a factual condition that must be proved na meron ka talagang redundancy. Sobra talaga. And in many cases, the Supreme Court said you can prove it by showing a reorganization plan, for example. You have to present the old organizational chart and the new organizational chart showing the situation of redundancy. So note that simple declaration by the employer will not be sufficient. The employer eventually, if there is a dispute, must be able to back up that declaration of redundancy with sufficient evidence that there is indeed a superfluity and that the current personnel complement is in excess of the needs of the operations. I would not consider this a major problem in this period. Because of the crisis, we know that many employer establishments had reduced significantly their operations. So I don't think this will be a major problem. But we have to guard against abuses. You cannot simply declare a redundancy program without an actual redundancy situation, without an actual need to reduce the number of employees. One important clarification. When we are talking about redundancy, it has nothing to do with losses. Hindi konektado ang redundancy sa financial situation. At least on the basis from the perspective of the requirements. So you don't need, if you are the employer, you don't need to prove losses. In fact, you can dismiss employees on the ground of redundancy, even if you are earning millions in net income. So termination due to redundancy is not directly related to a financially difficult situation or a difficult financial situation. So there's no correlation. So redundancy is simply a situation caused by circumstances, for example, the crisis, the pandemic, that would create a situation where employees are now in excess of the needs of the employer's operations. So no need for the employer to link it to losses. And that's a very important distinction between redundancy and the other grounds for dismissal, the other authorized causes for dismissal. Let us go to retrenchment. And let us explain the distinction between redundancy and retrenchment. Again, this is one of the authorized causes for the employer. In some cases, or in actual practice, this is referred to as layoff, downsizing, reduction of personnel. The law calls it retrenchment. And it's important for us to look at how it is worded in the law, in Article 298 of the Labor Code. The law uses the term retrenchment to prevent losses, not retrenchment due to losses. Okay? So under the law, retrenchment is not a result of losses. It is a preventive measure. So that's why the law uses the term retrenchment to prevent losses. So you cannot simply say, nalulugi ang kumpanya, pwede ako mag-retrench. No, it's the other way around. Magre-retrench ako para hindi malugi ang kumpanya. That is the consequence of that wording of the Labor Code. Retrenchment to prevent losses. What losses are required? So when the law uses the term losses, what losses? Losses must be substantial, must be serious. There is no quantitative formula. Hindi sinabi ng batas na ang pagkalugi mo, ganito kalaki, 10 million, serious or substantial. It will be on a case-to-case basis. And later on, we will discuss what proof you need to show. But a clear requirement is that the losses must be substantial, serious, grave enough to authorize termination. So hindi porket nalugi ka ng maliit, pwede ka na magtanggal. It is also important to clarify that losses may be actual or expected. Hindi kailangan na nalulugi ka na ngayon o hihintayin mo na malugi ka ng malaki bago ka makapagbawas ng tao. So it can be actual losses, it can be future losses. But there is a requirement as far as evidence is concerned for both actual and future losses. What should be the proof? What should be sufficient proof of losses? Mas madali yung actual compared to future losses. So yung actual, you can show audited financial statements. And the Supreme Court had clarified, it is not enough to show 1 year's audited FS. Hindi pwedeng 1 year lang. The Supreme Court said, if you are terminating, for example, today, then it is important that you show your audited financial statements last year, your financial situation, whatever you have this year, and you must show also that this will be a continuing situation next year and in the future. So it is not a simple burden on the part of the employer. Hindi madali na nalugi ka ng ilang buwan o isang taon, pwede ka na magtanggal under retrenchment. The Supreme Court said there must be a pattern. You must convince the court that what is happening now or what has happened will continue, and therefore you need to reduce your employees. So take note of that. Not just 1 year, but a continuing situation. You have to prove that this is a continuing situation. And this is a very difficult burden for the employers this time because nobody knows. Nobody knows what will happen. Nobody knows how long this pandemic will be. But take note that that is a requirement for substantive proof. So it's important for the employers to prepare their documentation on how the pandemic has impacted their operations. If you recall the Asian financial crisis several years ago, there had been cases that were elevated to the Supreme Court. And the Supreme Court said in some of those cases, it is not enough to cite a particular global or regional situation. The court said that an employer cannot simply say, oh, because of the Asian financial crisis, I have to reduce the number of my employees. The Supreme Court said that is not enough. So if we follow that, it is not enough for employees to say, because of the pandemic, we will reduce the number of our employees. The court, eventually, if there is a dispute, will look for a clear link between the pandemic, that situation, and your operations. And what is the reason for that? Eh baka naman mas kumikita ka because of the pandemic. That's a possibility. So the court said, we cannot assume that all employers are impacted similarly by a particular economic or financial situation that is regional or global. So you still have to prove the direct link between the pandemic and your operations, necessitating the reduction of your personnel. So take note, the pandemic can be used to justify retrenchment provided that the employers can show a clear link. It cannot be used as a simple excuse to reduce your personnel. You cannot cite it as a blanket justification for the reduction of personnel. Another important clarification about losses. Pag sinabi nating losses, pagkalugi. So when we say substantial or serious losses, malubhang pagkalugi. This is different from loss of income. Losses is different from loss of opportunity to earn. So what is needed here is losses, negative bottom line. Lugi ka, hindi ka lang nawalan ng kita. So there's a distinction. So let's take a simple example. Let's say 1 month, and we are looking at a short period just to simplify our example. Let's say 1 month, hindi ka nag-operate. Pero wala ka ring gastos. Okay? Wala ka ring gastos. Wala kang binayaran na rentals, wala kang binayaran na sweldo. You cannot claim na nalugi ako. Iba yung nalugi ka, iba yung hindi ako nakapagbenta and therefore nawalan ako ng kita. What is needed here is nalugi ang kumpanya. Of course, in real life, once you stop operating, once you reduce the level of your operations, in all probability, you will incur losses on a daily basis, on a monthly basis, because your overhead expenses are not suspended in the meantime. So as I said, during the pandemic, the employers should document these situations and should document the particular position of the company in relation to the pandemic and in relation to the impact of the pandemic on the particular business, on the operations of the business. Let us go to future losses. And this is a difficult issue concerning the evidentiary aspect. Pag actual losses, may mapapakita ka eh. May mapapakita ka na audited financial statements. You can show your bank statements if you're willing to do that. So yung wala talaga, nabawasan talaga yung pera ng kumpanya na ibenta itong assets na to because of that. Actual losses yon. But take note that you can terminate employees even if you do not have actual losses yet. Because this is preventive nga. This is in anticipation of future losses. What does the court say about this? The court said, well, future losses should be imminent, should be real, expected, imminent, certain, meaning sigurado ka na mangyayari. Hindi ka lang nagiging overcautious. You are not just projecting a potential situation. You are really expecting that you will incur losses in the future. And that is difficult to prove. The evidentiary aspect of that situation is difficult to prove, but it's a requirement nevertheless. So you need to prepare for that. You need to document the basis for your projection. Again, because you are not required, the employer is not required to wait for that to happen, for serious losses to be incurred. Di mo kailangan na maghintay na hanggang malaki na yung lugi, tsaka ka lang magtatanggal. The law gives the employers the right to do this, to reduce the personal complement. Again, because this is a preventive measure. It must be bona fide or in good faith. And take note, aside from proving that you have incurred actual losses, or aside from proving that you will certainly incur future losses, that future losses that are substantial in nature will be imminent, the court also requires the employer to prove that the retrenchment is expected to be an effective preventive measure. So hindi lang yung pagkalugi ang papatunayan ng employer. Papatunayan din ng employer na pag nagbawas ako ng tao, pag nagbawas ako ng empleyado, gaganda ang sitwasyon ko. And we go back to the reason for that, because retrenchment is a preventive measure. So the court requires the employer to prove, aside from losses, to prove that the retrenchment is reasonably expected to address the situation of losses. And if you cannot prove that, then you cannot prove an authorized cost. You cannot justify reduction of personnel. Similar to redundancy, retrenchment is not a termination of all employees. So this is not a wholesale dismissal of all employees. You are reducing your personnel complement, and therefore only some of the employees, or even let's say, even if it's a significant number of employees, hindi lahat tinatanggal. And because of that, you are required, the employer is required to have a criteria for selecting employees who will be part of the retrenchment program. And that is our next issue. How will you address this question? Let us say there's a company, and the company wants to reduce the number of employees because of the crisis. In selecting employees to be terminated, can the employer start with employees who are 50 years old and above? Pwede bang sabihin ng employer, kailangan natin magbawas ng tao, at ang tatanggalin natin, ang mauuna, yung mas vulnerable. So yung 50 and above. Bakit 50 and above? Kasi in all probability yung mga 60 and above ay nag-retire na. So kung meron man, konti lang yung natitira. But 50 and above, medyo marami yan. Can the employer do that? Can the employer select employees to be terminated based on age? Based on the rules and based on Supreme Court decisions, the employer can adopt its own set of reasonable criteria for selection. And the criteria can be a number of things. It can be status of employment, so regular and non-regular. It can be efficiency based on performance of the employees. It can be seniority. We will go back to that, the issue of seniority. Physical fitness, age, and financial hardship. This was mentioned in the rules. Financial hardship for certain workers. So pwedeng ang consideration mo, mas kailangan ito na magpatuloy sa trabaho kumpara dito. So ikaw tatanggalin dahil mukhang hindi mo naman kailangan ng trabaho. Okay, take note. The employer can adopt its own set of criteria provided that set of criteria is reasonable given the situation. Take note, however, that under the rules issued by the Department of Labor concerning to govern dismissal cases, the Department of Labor said that the LIFO rule, or yung last in, first out, should apply. Ano tong last in, first out? Essentially, seniority. Yung mas matagal na sa kumpanya, ang mahuhuli na tatanggalin. Okay? So yung pinaka-bago, pinaka-junior na empleyado, sila yung unang tatanggalin. And this has created confusion. Because in at least one decision, the Supreme Court said there is no mandate to apply the LIFO rule, but the Department of Labor said the LIFO rule should apply. My interpretation of the rules and jurisprudence and the law is that the LIFO rule, the last in first out rule, must apply, but in combination with the others, not automatic. So even if you look at the rules, there are provisions in the rules saying that you consider other factors. So you apply the last in first out rule, but you also look at other factors. The important thing is there has to be a clear set of criteria. Dapat alam ng mga empleyado o maintindihan nila bakit pinili si A na tanggalin, si B hindi. Pareho naman kami ng posisyon o sabay kami pumasok. That criteria will be presented later on if there is a dispute. So before you terminate, employers, you need to be ready with this, and you need to document how you selected the employees to be terminated. Take note, going back to the question, pwede bang age-based selection? Note that we have the Anti-Age Discrimination in Employment Act. So I would say hindi pwede na ang cut-off mo ay age. Because the 50-year-old may say, kahit na 50 plus na ako, mas malakas pa ako dito sa mga bata dito eh. So it will be very difficult for the employer to justify selection of employees on the basis alone of age. The question now is, will you be accused of violating anti-age discrimination, the anti-age discrimination law? If age is one of the factors, not the sole factor, but one of the factors that you consider, because it's a reality. The older you get, the more vulnerable you are to infection. I would say, based on the reading of the Anti-Age Discrimination Act, that as long as it is not arbitrary, as long as it is not a baseless discrimination, that is, the only basis is age, it will not be considered as a violation of the Anti-Age Discrimination in Employment Act. If we look at the wording of the Anti-Age Discrimination Act, the policy says it prohibits arbitrary age limitations in employment. It prohibits forcibly laying off an employee because of age. So if age is only one of the many factors that you consider as part of your set of criteria, then I would say you will not be violating the Anti-Age Discrimination in Employment Act. Let us go to closure. Okay? So pataas tayo ng pataas. Una, suspension of operations. And then second, you terminate, but only some, not all of your employees. Pagdating dito, closure or cessation of operations, tigil lahat. And therefore, you terminate all employees. Again, employers are given the right to do this, subject to the qualifications, the requirements that we will be discussing next. There are two types of closure as to the reason for the closure. One is due to losses, and the other is not due to losses. So an employer is not required to maintain its business unless there are serious losses. I'll give an example. Schools, your private schools. Let us say there is a small private school, and the owner of the private school, let's say it's a family-owned, so maraming ganyan, no? Family-owned private school. Let us say the owner of the school does not believe in online learning or even of blended learning. Ayaw niya talaga. Ang naniniwala siya na kailangan face-to-face interaction between the students and the teachers. And because of that, the owners of the school decided, tigil na tayo, sarado na natin ang eskwelahan. And I've heard some schools have done that. Is that authorized? Kahit na hindi nalulugi ang eskwelahan. Okay? Kasi as of last year, ganda pa ng kita niya. So wala siyang serious losses. Is the owner of the school allowed to close down the business even if there are no substantial losses? The answer is yes. The law authorizes the employer or any owner of a business to stop conducting the business even without serious losses. In the same manner, in the same way that workers cannot be forced to work for a particular employer, employers cannot be forced to continue their business operations. So hindi kailangan na may malubhang pagkalugi bago isara ang isang kumpanya. Pwedeng isara ang isang kumpanya kahit hindi nalulugi. Okay. We will go back to that when we talk about the requirements. There are two types as to extent of the closure or the cessation of operations. If you look at the law, the wording of the law says closure or cessation of operations. So ang tinutukoy talaga sa batas ay pagsasara, pagtigil ng operasyon. So that is complete. That is total closure. In some cases, however, decided by the Supreme Court recognized the validity of partial partial closure. Take note that partial closure is not temporary. Iba yung partial closure sa temporary suspension of operation. Let us give an example. Usually, when you say pwede ang partial cessation of operations, this refers to companies, big companies, where you can identify different sections, different departments. So even if there is only one corporation, there's only one establishment, only one entity, iba-iba yung section niya. May Department A, Department B, or let's say food, itong isa ay school supplies. Let's assume that there are different products. So the Supreme Court said, pwedeng ang isara mo lang ay isang section or isang department that can be authorized under Article 298, under closure. So pwedeng complete, pwedeng partial. I would not go to the extent of saying that it is allowed to have a partial closure if partial closure will simply mean reducing your personnel. Hindi pwedeng, yung mga nasa first floor, tanggal kayo. Maiwan yung second floor. That's not how you do it. That's not how partial closure is. Partial closure refers to a particular section or department identifiable as distinct from the rest. Hindi ito simpleng retrenchment or reduction of personnel, and then you will call it partial closure, because there are implications, especially on separation pay. But we will go back to that. So two types as to reason: due to losses, serious losses, and then not due to losses. Complete or total closure, or partial closure, or partial cessation of operations. Again, we have this general requirement that the closure must be bona fide or in good faith. So even if you don't have serious losses, required pa rin ang bona fide intention, the good faith intention on the part of the employer. So the example that I gave earlier, this example of the school, that would be an authorized closure, even without serious losses. That is a legitimate decision on the part of the employer, on the part of the owner of the school to do that. Take note, however, that if you are terminating or you're closing down the business due to serious losses, then the requirement of evidence, the requirement of proof will apply. So similar to our discussion on retrenchment, the same rule should apply. You have to prove by substantial evidence that you have incurred serious losses, and that because of the serious losses, you are closing down the business. And this is the difference between retrenchment and closure. Closure due to losses is clearly an effect of the financial situation, an effect of losses. So closure due to losses compared to retrenchment. Retrenchment is to prevent losses. Let us go to the requirements. And the requirements are generally uniform, subject to some minor differences for redundancy, retrenchment, and closure. 2 notices. Notice to the Department of Labor and notice to the employee or employees to be terminated. Let's talk about the notice to the employees affected by the termination. The decisions of the court would say this should be individual, given to each employee concerned, not through the union, not through a notice posted sa bulletin board or sa website ng company, not through an advertisement in newspapers. It has to be given individually to employees concerned. And this is a problem now because, as you know, it's very difficult to communicate. It's very difficult to send letters, to send mail. So if the company will adopt alternative modes of sending the notices, make sure you document that. Make sure you document that the employee received individual notices of termination. If you're sending it through email, I would say because of the pandemic, because of the unusual situation, the extraordinary emergency that we have, the court eventually will not fault the employer for not handing to the employee personally a letter, a hard copy of the letter, because of the circumstances. But it is important, however, for the employer to document the mode of the giving of the notice, the sending out of the notice, if ever there will be alternative modes. Even to the Department of Labor. The Department of Labor has issued an advisory saying starting June 16, 2020, that the Department of Labor will receive reports of termination, reports of flexible work arrangements, reports of suspension, or these are notices to the Department of Labor, to the regional offices, personally or online. I just don't know how efficient the online system of the Department of Labor is, but that is what is stated in a labor advisory that the department issued in June, on June 11, 2020. When should the notice be given? The law is very clear, and the decisions of the Supreme Court are very clear about this. Notice is prior notice, and prior means 30 days, at least 30 days before the effectivity of the termination. And this is the requirement. 30 days prior to the effectivity of the termination, the employee should be given the notice. The Department of Labor should likewise be given a notice. For termination due to redundancy, retrenchment, and closure, in general, and the next issue will talk about an exception. In general, there has to be payment of separation pay. Now, let us go to the payment, separation pay. How much should the separation pay be computed? For redundancy, so nag-iiba-iba depending on the cost. And therefore, it's important for the employer to identify the clear authorized cost that is the reason, that is the justification for the dismissal. First, for redundancy. Okay, just a caution. If you read the provision of the law, it is formulated in a very confusing manner. It says 1 month pay or half-month pay for every year of service, whichever is higher. You will always see that formulation. Ignore that formulation. Just think of it as having a 1 month pay, 1 month salary as the minimum, and then if the employee has been with the company for at least 1 year or for a longer period, then the separation pay will be computed on a per year basis. And a fraction of at least 6 months will be considered as 1 year. So for redundancy, ang minimum na matatanggap ng isang empleyado na tinanggal ay 1 buwang sweldo. Kung medyo matagal na siya sa kumpanya, ang computation ng separation pay niya ay per year of service. Kalahating buwang sweldo per year of service. So let's say you've been with the company for 1 year. Magkano makukuha mo? 1 buwang sweldo. Pag nasa kumpanya ka ng 2 taon, magkano makukuha mo? Ganun pa rin, 1 buwang sweldo. Kasi pareho lang yan. Pag kinompute mo ng minimum 1 month or kinompute mo ng per year of service, equivalent yan to 1 year, to 1 month salary. On the other hand, kung 3 taon ka na sa kumpanya, so tinanggal ka based on redundancy, then you benefit from the per year of service computation. Because your years of service will now be multiplied by half-month salary. So ang makukuha mo in that case ay 1.5 months salary for the 3 years of service. That's how you compute it. Ignore that confusing formula na 1 month or at least half month for every year of service, whichever is higher. Similarly, you follow the same formula for retrenchment and closure not due to losses. Meaning, minimum of 1 month salary, 1 buwang sweldo. If you have been with the company for at least two years, then you, for separation pay, the distinction is separation pay is 1 month salary, period of service. So going back to our example earlier, kung 3 taon ka na sa kumpanya at redundancy ang ginamit na dahilan ng employer mo, so ang separation pay mo will be equivalent to 3 months salary, 1 month for every year of service. On the other hand, kung ang dahilan ng kumpanya ay retrenchment or closure not due to losses, minimum of 1 month, and then per year of service, it will be computed half-month salary. So dito mag-a-apply yung naka 3 years ka na sa kumpanya, tinanggal ka based on retrenchment, you will get 1/2 for every year, and therefore 1.5 months salary for every year of service. So if you compare the separation package, mas mataas sa redundancy. Because the situation is different. In redundancy, as we have said earlier, this can be done even without losses. Pero walang distinction sa batas kung yung redundancy mo ay due to losses or not due to losses. Ang distinction with respect to losses ay closure. Closure, not due to losses, will merit the payment of separation pay to employees terminated. On the other hand, if closure is due to serious losses, then based on jurisprudence, sabi ng Supreme Court, walang liability ang employer na magbayad ng separation pay. So it's important to look at the distinction. Pinakamataas ang package pag redundancy, 1 month for every year of service. Sumunod ang retrenchment and closure not due to losses, half-month salary for every year of service, and then 0 for closure due to serious losses. Finally, illegal dismissal and defective dismissal. How do we make a distinction? Pag illegal dismissal, walang dahilan, walang legal justification. So there is no authorized cause. So hindi ka talaga nalulugi, pero nag-declare ka ng pagkalugi. Nagbawas ka ng tao without serious business losses. Kine-claim mo na retrenchment pero hindi mo mapapatunayan ang serious business losses. That will be considered as an illegal dismissal. On the other hand, if you have an authorized cause for dismissal, meron kang justification, but you did not follow the procedure, hindi ka nagbigay ng notice, ng 30-day notice to the Department of Labor or to the employee, the dismissal is not considered illegal, but merely defective as to the procedural requirements. So magkaiba yun. Magkaiba kasi ang consequences. Magkaiba ang remedies given to the dismissed employee. And that will be our final issue, and then we can go to questions. If the dismissal is without cause, it's an illegal dismissal, the employee is entitled, the employees terminated will be entitled to reinstatement. That's the general remedy, the primary remedy. If reinstatement is not possible, then the employee will be getting separation pay in lieu of reinstatement. Plus, full back wages. Ang back wages, kung tinanggal ka sa trabaho, let's say, by September, nagsampa ka ng kaso, at yung kaso mo ay nanalo ka, at tumagal yung kaso mo ng 10 taon, yung back wages mo ay 10 taon ang coverage. Hanggat hindi ka binabalik ng kumpanya kung may reinstatement order. Ibig sabihin, yung back wages, parang sumusweldo ang empleyado habang siya ay nagkakaso. Kinakasuhan niya yung employer niya. From the time of dismissal up to the time of reinstatement, if reinstatement is ordered. So this is a very serious liability for employers. So you have to be very careful, employers. You are risking the payment of a huge amount, especially kung may mass dismissal. Kung maraming empleyado yung sabay-sabay tatanggalin because of retrenchment or redundancy or closure, malaking amount yung babayaran nyo for the back wages. So for every month, kumikita ang empleyado nyo in terms of back wages. On the other hand, if you have a cause for the dismissal, but you did not follow the procedural requirements, then it is not an illegal dismissal. It is merely a defective dismissal. So if it is a defective dismissal, no reinstatement will be ordered, no back wages will have to be paid by the employer. Papagbayarin lang ang employer ng damages. Damages. Sa ngayon, ang going rate sa decisions ay 50,000 pesos damages for the causes that we have discussed, for authorized causes, redundancy, retrenchment, closure. I'm looking at the time. We can stop here and we can entertain questions about what we have discussed and about any other related issues concerning the employer-employee relationship during the pandemic. So back to you, Martin.
Thank you, Marlon, for that very informative lecture. And I'm sure a lot of our viewers have many questions for you. In fact, I see many of them already. But before we let you answer these questions, we'll let you rest a bit and show some slides about the LI. Okay, thank you again to the generosity of all sponsors who have made today's lecture possible. Marlon, are you ready to answer the questions?
Yes, sure.
Of all our viewers? All right. Let's start with a question from Sinagtala Solas. So good afternoon, Attorney Manuel. How might we compute the 13th month pay of workers who are placed on forced leave, no work, no pay, or are with employers who are temporarily closed or non-operative? Thanks, sir.
Okay. Madali lang po yung pag-compute ng 13th month pay. 13th month pay is not really equivalent to 1 month salary. The formula for computing the 13th month pay is whatever you have received in a particular year as your salary for 1 year, you divide it by 12. That's your 13th month pay. So, for example, you received your salary only for 6 months during this year because of the suspension of work, suspension of operations. So your 13th month pay will be computed as 1/12. So you just divide the total salary that you have received for the 6 months that you have worked, divide it by 12. That will not be a problem. Ganun po talaga ang computation ng 13th month. Kung anong kinita mo sa loob ng isang taon, divided by 12. That will be your 13th month pay.
Okay, thank you, Marlon. Next question is from Elizabeth Ann Vuharne. I hope I'm pronouncing your name properly, Elizabeth. And the question is, what if the employer dismissed the employees before the 6-month period of forced leave?
What if the employer dismissed the employees before the 6-month period of forced leave?
Yes.
Okay. So the situation is that the company suspended operations because of the pandemic, but before the end of 6 months, there is a termination. That can be done. The employer need not wait for the end of the 6-month period. The 6-month period is a maximum. It's a limit for the temporary suspension of operations. If on the 4th month, for example, the employer decides to terminate the services of the employees, and there is an authorized cause, there is a justification, then the employer need not wait for the end of the 6-month period. Pwede na siyang magbigay ng notice 30 days before the effectivity date of the dismissal. So hindi niya kailangan hintayin na matapos yung 6 months.
Okay. So what if there's no cause, Marlon? They just want to terminate. So of course you follow the rules.
If there is no cause, then that will be considered an illegal dismissal.
All right.
You should be able to justify it based on redundancy, excess of employees compared to services, or retrenchment because you want to prevent losses, or you are closing down the business. You think the business is no longer a feasible enterprise.
That's the prerogative of the employer, right, Marlon?
Yes.
Yeah.
That's a prerogative of the employer. Subject, of course, to the requirements, and especially the payment of separation pay, if applicable.
That's right. Also from Elizabeth, I think it's a related question. Do labor advisory numbers 9 and 11 allow employers to force leave employees even without suspending its operations?
Yes, this is exactly the situation of floating status or temporary layoff or off detail. So you are not suspending your operations, but some employees are placed on a prolonged period of not working and therefore not receiving salary, not receiving their pay. That's allowed, provided you will not exceed 6 months.
All right. Actually, I was about to raise that concern, Marlon. A lot of questions here have to do with that 6-month period. We'll get to these questions later, but even I myself am interested to know. Because, we're not sure how the situation will change after September 15, right? So, okay, we'll get to those
That's
questions.
right. That's why I'm calling the attention of the Department of Labor and Secretary Bello. If we are optimistic, like what happened in Boracay, it reopened at the end of the 6-month period. So hindi nagkaroon ng problema doon sa maximum of 6 months. We are nearing the end of the 6-month period. So if we are optimistic, then we can say, dapat siguraduhin na at the end of the 6-month period, pwede nang mag-resume na operations ang mga employer. But if that is not expected to happen, then the Department of Labor should be prepared for this.
Yes, yes. Okay. Next question, and I can't really tell what her name is because it seems to be in Japanese or Korean. So, there. Is that Japanese or Korean? And what if the employee under floating status gained employment in another company? Will there be a violation of his or her employment contract with the original employer?
If you're asking for the contract itself, for a specific violation, then you have to look at how the contract is worded. But I would say that in general, if you are looking for alternative sources of income in the meantime, when you are under floating status, as long as you are not severing, you are not ending your relationship with your original employer. Which means, pag pinatawag ka at pag pinabalik ka sa trabaho, babalik ka, then that will not be held against you, because you cannot be prevented from looking for other sources of income when you are placed under floating status. Again, with the caution that if your employment contract prohibits that, and especially, let's say, there's a prohibition for working in a competitor company, then that is something else. But otherwise, I would say we cannot hold that against an employee who is not receiving income from the employer.
Right, thank you. Yes, I was about to mention the possibility of valid non-compete clauses in the employment contract.
That's right. That's right.
You mentioned also earlier, Marlon, that there must be an agreement between the employer and the employees regarding these temporary work arrangements. Okay, and if it goes beyond 6 months without an agreement, mayhem may ensue. I mean, and I think especially for the employer. I mean, in a situation like what we have now, where everyone all over the world, regardless of status or situation, is adversely affected, right, by the pandemic. Isn't it better? Isn't it the lesser evil, in fact, to keep as many employees as you can, right? Although not paying them their usual full, or giving them their usual full benefits, instead of just closing your company altogether. Isn't that being taken into consideration?
Yeah, I agree. And in fact, that's why when we discussed the four areas, it's graduated from the mildest to the most severe. If the employer will choose, and of course we prefer that the employees not be terminated. Right. The only problem is that based on the law, the employer can only do that up to a certain point. That's why the Department of Labor should come in and issue an advisory on what to do with the situation. If by September 15, many establishments cannot resume operations, how can they address the situation? Are they forced to? Are the employers forced to terminate in order to avoid potential liability? Take note that if you do not terminate under the law and under jurisprudence, it's constructive dismissal beyond 6 months. Right. I agree that it may be better for both parties to have just a prolonged suspension of operations instead of terminating the employment. But we need to have clear guidelines on how that will be done. Otherwise, again, as I said, employers will run the risk of liabilities for that.
Agreed. Okay. From KC Pakleb. Sir, can there be temporary suspension and temporary layoff at the same time? For example, for a particular branch of a company. Again, I think she's referring to the same company laying off temporarily and suspending, but from different maybe departments.
Yes, that's possible. Take note that the rules are more relaxed pagdating dun sa temporary suspension because you are not terminating the employment relationship. So if for example, one section was temporarily had a temporary suspension of operations for one department, and then for the other department, it's still operating, but some of the employees are placed on temporary layoff. That can be a possible combination. Again, both are limited by the 6-month period.
Okay, thank you. Now again from Elizabeth, and her question is, what if the employer still receives 100% payments or fees from their clients, but reduces the salary of employees and places others on forced leave using the pandemic as a reason? Isn't this using the pandemic as a subterfuge for them to fail to give the salary or the proper salaries per employment contract?
Okay, there are two separate issues there. One is reduction of salary. The other is placing others under forced leave. Yung forced leave, that will be covered by our discussion on floating status. So as long as it is done because of a valid business reason and it will not exceed 6 months, then that's valid. Reduction of salary is something else. The employer cannot arbitrarily reduce the salary of the employees. If you are performing the same kind of work, then the employer is not justified to reduce your salary, your compensation, simply because of the pandemic. Hindi pwedeng ganon. There are advisories of the Department of Labor saying if there is a union, it can be discussed as part of the CBA. But what is clear is that the employer cannot unilaterally reduce your compensation if you are performing the same amount of work.
All right, but I suppose, Marlon, what everyone just needs to know is, as long as you're working, let's say, under flexible work arrangements, and so you have reduced days or hours, then a reduced salaries is justifiable, right?
Oh yes,
6 months.
Definitely,
correct?
definitely.
Yes.
Lugi naman yung employer pag ni-reduce ang working days mo at working hours mo, pero hindi i-reduce yung salary mo. That's why in the cases that we cited earlier, the court said pag significant yung reduction ng work hours, significant ang reduction ng salary, it could amount to dismissal.
Right.
Because compensation is your main consideration.
The example you gave earlier, Marlon, pertains to a reduction to 40%, assuming it's a 5-day work week for the employee, and the employee is just required now to come to the office 2 days in a week, right? So what would be, is there a strict benchmark, or what are the parameters for determining what's a substantial loss?
Yeah, there's no quantitative formula. Yeah, there's no threshold. The court did not say pag reduce by 20%. So it will be on a case-to-case basis depending on the situation of the company. That's why I'm emphasizing the need for employers to document everything and prepare your justification as early as now. You don't want to be doing a late documentation pag meron ng case na na-file against you. So if you're doing this, if you are adopting the flexible work arrangements, you have to document everything. If you are meeting with your employees, if you are discussing this with the union, then you have to document everything for the protection of the employer.
All right. Okay. Again, from Sinagtala, Attorney Manuel, in redundancy and retrenchment, does the labor study need to be done by a third party or auditor, or can the employer do it themselves?
I think the question is referring to the proof for the existence of redundancy. It need not be an independent. It could be an independent study, but it's not required. As long as you can support your implementation of a redundancy program. It need not be an independent study. The company can do its own study, can do its own reorganization plan, and that can be presented as evidence of redundancy.
All right. So what you're saying, Marlon, is it will not necessarily be held to be self-serving if the company itself gives the study.
Yes, that's right. That's right. The company is not required to hire an independent consultant to do it.
Yeah, well, especially nowadays where that will entail additional costs, right? So
yeah. The company in many cases, an employer can have its personnel department do the study.
yes,
So hindi kailangan na independent.
yes. From an unnamed alumni of the or as a member of the LAI, regarding forced leave or temporary layoff or closure, what can the employer do, if any, if he or she wants or needs to further extend the forced leave or temporary layoff, temporary closure for more than 6 months? I think this is a question that many are asking. If there are no other remedies, is the employer then forced to terminate? If so, how much separation pay should be paid to the employer?
My suggestion to the employers, especially to the employers associations, to the employers groups, as early as now, you seek the Department of Labor's advice on this. And the Department of Labor should be able to give us a clear advisory, a clear guideline, so that will protect the employers if ever they decide to extend the suspension of operations instead of terminating, which, as we have said earlier, could be beneficial to all parties. Na instead of terminating, i-extend mo pa, baka sakali na matapos agad ito in a few months time after September. But I suggest the employers groups go to the Department of Labor as early as now and ask for a clear advisory and guidelines. If the Department of Labor will say pwedeng i-extend but subject to the following requirements. Ginagawa na naman ng Department of Labor yan. But we have to do that. Otherwise, employers will not be protected, and we apply the whole package of consequences for not doing that.
All right. In anticipation of a ruling that's not favorable to the employer, would you recommend making a blind query? Is that possible? The DOLE, or must all identity be divulged?
Well, even a single employer entity can request, can write to Secretary Bello to do that.
All right.
Hindi kailangan na the big employers groups.
Yes.
But this is a major concern for all of us in the next few weeks.
Agreed. And September 15 is fast approaching.
September 15.
A question: based on recent DOLE issuances, an employer can put an employee on forced leave, okay, as flexible work arrangement for as long as the pandemic exists. Can the employer place an employee on forced leave? I think we've answered this, beyond 6 months, right?
Under the current law, 6 months lang talaga. And jurisprudence, the court is very clear about that. 6 months lang, floating status.
Okay. All right. Another question here. When an employee on floating status is redeployed, but subsequently put on floating status again, is the second period covered by a new 6 month period? I think the 6 month pertains to March to September, right?
Yes. I think what the question is referring to is a situation where after, let's say, a few months of being given being given work, may assignment ka na ulit, ni-recall ka na, let's say before the end of 6 months or after 6 months. Do you start counting 6 months again kung eventually nag-float ka? The answer is yes. At yan yung nangyayari sa mga security guards. So floating ka, then bibigyan ka ng trabaho dahil may kontrata yung security agency with a company, a client. And then after nun, wala ulit. So floating ka ulit. So hindi mo ina-add lahat. So for every floating, the 6 month period is maximum for each floating status period.
All right. Okay. Relatedly, for employees who are placed on floating status for 6 months, are they entitled to a 30-day notice if they will be separated? I think the answer is yes.
Oh, yes, definitely. Pag tatanggalin mo na, in fact, even for temporary layoff, may Supreme Court decision na nagsasabi na kailangan din ng notice. And the Department of Labor also follows that. So may yung report to establishments sa Department of Labor, kasama rin yung temporary suspension of operations na kailangan mag-notify yung employer.
Okay. From the Alumni Association as well, can an employer separate its employees on the mere ground of COVID-19? If not, how will the employer determine the legal basis for reduction of personnel? Would it be redundancy, retrenchment, partial closure?
I'm trying to understand if the question is asking about a particular employee who tested positive for COVID-19, or if simply citing COVID-19 will be enough? If the second, mukhang yung second, no?
Yes.
Is it enough to say, dahil COVID-19 tayo, dahil may pandemic, pwede ako magtanggal? No, it's not enough. As we have clarified earlier, you have to identify your particular authorized cause. Kung redundancy, you have to prove it. Sobra ang tao because of the pandemic. Bumaba ang demand for services or for the products manufactured by the company. Pag retrenchment, maraming losses, serious losses. So I need to prevent it. Pag closure, then due to losses, you also have to prove it. You cannot simply cite as a blanket justification, we are in a pandemic and therefore I can terminate employees. Ito yung nangyari nga doon sa Asian financial crisis. The court said, you cannot simply invoke the Asian financial crisis and then magtanggal ka ng tao. Dapat ipakita mo anong epekto sa'yo ng crisis, anong epekto ng crisis doon sa actual operations.
Right. Okay. You mentioned or another situation where an employee has contracted the virus. Okay, so here's a related question. News reports last Monday, August 17, say that employers are required to pay some sort of COVID allowance to COVID-positive employees. Is this true?
Okay. If you check the press release, yung press statement ng Department of Labor, meron silang press releases doon sa website. There's a statement attributed to Secretary Bello saying employers must give employees the COVID allowance. But if you check the DTI, the Secretary was referring to the DTI DOLE joint memorandum, the guidelines. Pag tinignan mo sa guidelines, it's not a requirement. The provision says employers are encouraged to give extra allowance. So it's not a requirement under the guidelines, under the joint DOLE DTI memorandum. So hindi required.
Right. So this is not exactly an allowance, but for example, Marlon, it's not GCQ. Let's say it's ECQ or MECQ even, and public transport is still not normal, no? In fact, or not existent for many. But you require some of your essential employees to report for work. For example, to prepare the bills, do the collection, etc. And I understand you are required to provide them with transportation and some additional allowances.
This is another
by the DOLE.
Yeah, this is another aspect of the memorandum that is confusing, no? Because of pronouncement from the Department of Labor. If you check the memorandum, even for the testing, for example, testing of employees, ang ginagamit na term sa memorandum ay encourage. Employers are encouraged. Pagdating dun sa yung providing shuttle service, there's a category, yung large companies, large employer establishments. If I'm not mistaken, 15 million yata yung assets na nakalagay doon, which is not really big, no? 15 million is not really big for enterprises. Mm-hmm. The term used is enjoined. Right. Employers are enjoined. Hindi categorical na requirement or mandated to provide. So if you look at the whole memorandum, the DOLE DTI joint memorandum, the spirit is not to mandate employers to give the different benefits. The underlying policy is just to encourage the employers to provide the allowance, to provide to pay for the cost of the regular testing, and then the shuttle service.
Okay, so that's DTI DOLE Joint Memorandum Circular number 20-04. Okay. Question here, I think, is that correct?
May nilabas nung August 14 lang.
Okay, so later pa.
Yeah, so this is supplemental guidelines. So dated August 14, just a few days ago. Okay. Just a few days ago.
We can share it. Here, hi Martin, in case you see, sorry. Will the period of flexible working conditions, so reduced working days overlap with a subsequent cessation of operations, do they consume the same 6-month period? So if the period...
Yung flexible work arrangements, they are not considered a suspension of operations.
Yes, okay.
If what is meant is rotation, reduction of work hours, yung sinasabi ng Department of Labor's advisor, they are not really covered by the 6-month period.
Okay.
Unless talagang floating, walang trabaho for a long period, or suspended operations. Pero yung rotation, reduction of work hours, they will not fall under the suspension of operations program, which is covered by the 6-month rule.
Okay. So I think you discussed this earlier, but a question from Borge here is in relation to are there criteria in selecting which employees are to be placed on floating status due to the pandemic? I think you mentioned earlier it's really difficult. No? There's no hard and fast rule.
Yeah, and take note, as I said earlier, mas relaxed ang rules pag floating status kasi hindi ka tinatanggal eh. So we have to be more liberal for the employers pag floating status. Like, of course, it has to be in good faith. That's the fundamental policy, but we apply a stricter requirement when it comes to termination, yung criteria for selecting employees to be terminated.
Okay. Now, the next two questions are related and pertain to the 30-day notice. Okay. From Tolitz Gobot, Attorney Manuel, can a 30-day notice requirement be waived?
Okay. There are, I would say, two conflicting decisions about this. Okay. There's one decision saying that the 30-day notice cannot be replaced by 1 month's salary. Usually, this is the practice, no? By some employers. So you will be terminated, but instead of giving you a 30-day notice prior to the effectivity of the termination, hindi ka napapasok bukas. So in effect, wala ka ng trabaho bukas, pero may sweldo ka pa for one month. So that, according to the court, cannot be done. The court said it's a mandate of the law, and maganda yung explanation ng court pagdating dun sa decision niya na yun. Sabi ng court, the 30-day notice is not only for the purpose of allowing the employee to look for work elsewhere, hindi lang para maghanap siya ng bagong trabaho, but to prepare the employee psychologically for the loss of the job. So sabi ng court, hindi mo pwedeng basta palitan, ito na, tanggal ka na sa trabaho, pero may sweldo ka pa for 1 month. Because that is part of the psychological preparation. Mm-hmm. There is another decision, however, saying that the employer may give the employees terminated the notice, and then the employer has the option not to require the employees to work and instead to give them 1 month's salary. So in effect, in that second decision, pinapayagan ng court basta meron kang 1 month's salary. So as I said, two conflicting rulings by the court. I would say, because we are in a pandemic now and you are not at work. Most employees are not at work, di ba? So pag dumating sa iyo yung notice, hindi naman mag-a-apply yung ito nang sweldo mo kasi wala ka namang sweldo in the first place. Because we follow the no work no pay. The no work no pay rule. So the 30-day notice should still apply. So the issue of waiver will not be material if you are not working. If you are working, if you are at work, whether at home or you are reporting for work to office, then that becomes material. I suggest it's safer for the employers to still give the 1 month notice prior to the effectivity. So pabayaan yung magtrabaho muna yung employee for 1 month, especially if the services are needed. But for those who are not working, then that's not really material.
Agreed. Related to the 30-day notice, if we send notice now, so I guess they're anticipating that by September 15 there will be no extension of the 6-month period. Will the employer violate this 6-month period under the labor code? Okay, supposing operations temporarily ceased last March 15.
I would say in that case, no. Even assuming na kulang ka ng a few days, I don't think the employer will be sanctioned for having a few days of excess beyond 6 months. I don't think that will be applied strictly by the Supreme Court.
All right. Now time is
kasi August ano na pala ngayon, ano?
Yes.
August 19. So so technically less than a month, less than 30 days na by the time we end the 6 months.
Yes. Okay. From Kiko Africa, Attorney Marlon, for separation pay, what is your position in giving the same in installments? Is that possible? Given the current situation affecting many.
Given the current situation, again, as I said, this is an unprecedented event, no? And we also have to be patient with the employers. So I would say, as long as it is clear in your notice, in your agreement with the employees, there is no abuse on the part of the employer, and hindi prolong yung period ng installment, no? I would say the employer can resort to a different mode of payment. Take note, however, that the idea of separation pay is really a one-time payment. One-time payment kasi nga tinatanggalan mo ng trabaho yung tao eh. That's why if you are adopting a parang flexible payment scheme for the separation pay, then you have to be very careful in how you document it and how the employees will react to it. So better put everything in writing, agree on it, be clear about it, because again we're all victims of this crisis. So employers and employees together should work this out.
Right. Okay. Last two questions, and these are related. Okay. From Patricia Lucia Lim, in the criteria for redundancy, can an employer use being immunocompromised as a criterion?
Yeah, I would say yes. That can be part of it. As I said earlier, there are different factors that you can include in your set of reasonable criteria. So being immunocompromised can be one, because it exposes that employee to possible infection and also the co-employees. As long as there is no arbitrariness in the selection, the employer can justify the criteria.
All right. And the last question from our very own Mitoy Cayosa. For probationary employees, when ECQ was imposed, the probationary period was suspended. When did the probationary employment resume in order to count when the 6-month period is reckoned? To determine when the employee will become a regular employee. Is it after ECQ, MECQ? This is assuming that the company was able to resume continuous operations on GCQ.
If you look at the intent and the reason for probationary period, it is to determine the performance, the capacity, the capability of the employee for regular employment. So I would say it's not so much the status of, it's not so much whether we are under ECQ or MECQ. If it is when the employee reports back to work and resumes the job. So hindi talaga siya dependent on the status or the quarantine situation that we have. As long as the employer will have that opportunity, then dapat tumatakbo yung probationary period.
Okay. Pahabol lang, Marlon, last from again.
Yes.
if the money received by the social amelioration program is it part of taxable income or exempt? Would you know?
I would not consider that income. Although it's the BIR, that will eventually determine. But if we look at the nature of the program, it's not really income. It is a social. It's part of a social program, social amelioration, social assistance program of the government. So I don't think it should be considered as taxable income.
All right. Okay. We have many other questions posted here. Unfortunately, we don't have enough time for our guest, Attorney Marlon, to answer all of these. Don't worry, we will forward all these questions to our guest. And if possible, Marlon, I don't know, maybe if you're free, maybe we can schedule another session. There are so many questions for you. If you're available.
Yes, again, as I said, we have to navigate through this crisis together. So these we don't have the ready answers. What we have discussed today, the issues and the answers that we have presented are based on laws and jurisprudence before the pandemic. This is the policy framework before the pandemic, but we have to be conscious and we have to be flexible. And the government and eventually the Supreme Court should also recognize the difficulty of adjusting to the situation. So I would say that what we have presented are the laws as applied and jurisprudence decided by the Supreme Court on the application and interpretation of the laws. But it may require some flexibility. It may require some adjustments because of the current unprecedented crisis. So that is something that we need to discuss further with each other, employers and employees, with labor unions or even without labor unions, and then employers and employees with the government, and especially with the Department of Labor and the Department of Trade and Industry. So this is something that we need to continue the conversation because this crisis will not be over in a few months' time. No matter how optimistic we may be, unfortunately.
All right. Well, Marlon, thank you so much for your time this afternoon.
Thank you, Martin.
Hopefully, we can schedule another session because so many of our viewers have many more questions to ask. Okay. So before we end this afternoon's program, we'd like to reach out to the audience, everyone watching here today, especially to the alumni of our beloved alma mater, and supporters and fellow lawyers at Ateneo de Manila Law School to help the Alumni, especially in this web lecture series, Father Bernas web e-lecture series. You know, the Alumni has come a long way from its original all-male-dominated social group to which is now a more engaging and progressive association of alumni. Our persistent efforts to decongest the jails and provide legal assistance to those who have less in life these past years are laudable, and we urge you and implore you to give your support to the Alumni. For those who don't know, we have already sponsored at least 12 scholars, all of whom are now doing well in the practice of law, and many of whom, upon graduation from the Ateneo Law School, instead of joining big firms or prestigious companies, deemed it proper or better for them to join the government service, and they work in the public attorney's office, for example. These are some of our scholars. So we implore all of you alumni to support us, the Alumni, even by simply paying your yearly membership dues or lifetime fees, or by joining our activities and advocacies. So again, we always welcome the support of all our generous contributors to allow us to continue with this web lecture series. So thank you all for watching, alumni or not of the Ateneo Law School. We hope that our illustrious guest has been able to impart his expertise and knowledge on what is a very relevant topic that is affecting all of us today. So for the alumni, though, we urge you to join us, join the Alumni, and make a difference, not just as lawyers, but as persons who live for the greater glory of God. So with this, we'd like to end today's program, and we wish all of you a good afternoon. Please keep safe and stay healthy. Goodbye.
The Ateneo Alumni Association has evolved from its image of a boys' club in the early years to the image of an active alumni association of men and women for others.
I think it's very important to remember that the Ally performs a very important education value. The education of our graduates ends not with graduation, but with their continuing practice in introduction into the legal world.
This is a big task, but I believe everything is possible as long as you believe in our dear Lord. And as Atenean lawyers, we do believe, and with your help, we will be able to do it. Let us continue to be men and women for others. Join the Ally.
Join us! Join us!
Join us.